Response by the official representative of the Russian Ministry of Foreign Affairs, MV. Zakharova, to a question from Rossiya Segodnya International Information Agency regarding changes in the procedure for issuing Russian visas to foreign citizens. Question: On August 15, the government of the Russian Federation signed Decree No. 335 on amendments to the Decree of the Government of the Russian Federation of June 9, 2003, No. 335, hereinafter referred to as the Decree, concerning the issuance of Russian visas to foreign citizens. Who initiated this document? What will change in practice for foreigners? Will it be more difficult to obtain a Russian visa than before? Answer: The decree was developed by the Russian Ministry of Foreign Affairs, Consular Department, on its own initiative to enhance the effectiveness of implementing the provisions stipulated by Articles 25.10 and 26 of Federal Law No. 114 FZ of August 15, 1996, on the procedure for departure from the Russian Federation and entry into the Russian Federation. Specifically, the amendments made to the regulation on the establishment of the visa form, the procedure and conditions for its issuance and extension, the restoration of its validity in case of loss, and the procedure for visa cancellation, approved by the decree of the Government of the Russian Federation of June 9, 2003, No. 335, hereinafter referred to as the regulation, address several gaps in the legal framework concerning the verification process of a foreign citizen's declared purpose of travel to the Russian Federation and the conditions of their stay in the country during the visa issuance process. Thus, the decree provides for the possibility of Russian diplomatic and consular officers conducting a personal interview with the foreign citizen at the stage of reviewing their visa documents. Granting such authority to Russian diplomatic and consular staff will improve their ability to identify individuals whose presence on Russian territory may be undesirable, as well as to monitor the entry of foreign citizens who pose a higher immigration risk or come from regions characterized by unstable socio-political conditions. These changes do not, however, restrict the applicant's right to submit additional documents to demonstrate that the declared purpose of their visit to the Russian Federation and the conditions of their stay in the country align with their actual intentions. Such documents might include copies of invitations, contracts, work permits, guarantee letters from the inviting party, return flight tickets, and other documents proving the applicant's financial means for staying in and subsequently leaving the Russian Federation. It is important to note that in such cases, these documents must be duly reviewed by the consular officer and attached to the foreign citizen's visa application package. The aforementioned measures are aimed both at protecting the interests of applicants for Russian visas by optimizing the process of verifying the authenticity of the information provided regarding the purpose of their trip to the Russian Federation, and at combating illegal migration and preventing the use of Russian territory for unauthorized entry into neighboring countries. Moreover, the decree updates the condition stipulated in the first paragraph of Section 9.1 of the regulation, introducing the requirement that a Russian visa may only be issued to a foreign citizen residing in a country that is not their country of citizenship if they have a document confirming their residence in that country for more than 180 days. Previously, the requirement was for more than 90 days. This imperative is introduced due to the fact that the migration laws of certain foreign countries now allow continuous temporary residence for foreign citizens for periods exceeding 90 days, typically up to 180 days. This situation creates undesirable advantages for citizens of countries that deny Russian citizens visas in third countries, placing them in a privileged position compared to our citizens. Additionally, we cannot rule out the possibility of these third country migration rules being exploited by citizens of foreign states with high migration risks or unstable socio-political environments to obtain Russian visas, thereby complicating the verification process to uncover potential links to extremist activities or terrorism. However, this requirement does not apply to foreigners who are in a country that is not their country of citizenship and are applying for a transit visa, as their return to their homeland may often only be possible through transit via Russian territory, particularly when alternative routes are unavailable.